After exploring the strict registration and disclosure requirements imposed on timeshare developers under Arizona law, it is equally important to understand the rights afforded to purchasers once a timeshare transaction has occurred. The ability of a buyer to rescind or legally cancel a timeshare contract is one of the most powerful consumer protections built into Arizona's Timeshare Act, ARS, Sections 32-2197 ATCQ. These rescission rights serve as a safeguard against deceptive sales tactics, high-pressure presentations, or misunderstandings about the nature of ownership being purchased. Under ARS, Section 32-2197.03b, the purchaser may cancel the purchase agreement without a penalty or obligation within 10 calendar days, or another time period if applicable, after the purchaser signs the purchase agreement. This means that for 10 full calendar days after signing the contract, the purchaser may cancel the transaction for any reason, or no reason at all, without penalty. The rescission period begins the day the purchaser signs the contract or receives the last of the required disclosures, whichever occurs later. The purpose of this rescission right is rooted in Arizona's commitment to fairness and informed consent. Timeshare sales environments are often fast-paced, emotional, and filled with promotional incentives that can cloud a buyer's judgment. The 10-day window allows buyers time to review all documentation at their own pace, seek legal or financial advice if needed, and confirm that the purchase aligns with their long-term goals. For example, imagine a couple visiting a Scottsdale resort who attend a sales presentation and are offered a limited-time deal on a 1-week timeshare. They sign the contract impulsively after being told the offer expires that day. Once home, they realize the maintenance fees are higher than expected, and the week they purchased is not guaranteed during their preferred vacation season. Within 10 days, they can submit written notice of cancellation to the developer, and the contract will be voided with a full refund. This safeguard reflects Arizona's recognition of the imbalance between developers' sophisticated marketing techniques and the consumer's need for protection. To exercise the right of rescission, the purchaser must deliver written notice to the developer within the 10-day period. The notice must clearly indicate the purchaser's intent to cancel, but does not need to follow any specific format. It can be hand-delivered, mailed, or transmitted by electronic means if the contract permits. Under ARS Section 32-2197.05 A2, the developer must refund all payments, including deposits, fees, and any other consideration, within 15 business days after receiving the cancellation notice. If a purchaser cancels the purchase agreement pursuant to the agreement's terms, the monies shall be paid to the purchaser or paid to the developer if the purchaser's monies have been previously refunded by the developer. A key distinction must be made between a rescission and a termination for cause. A rescission under this statute is unconditional and time-limited, whereas termination for cause may occur later if the developer or seller breaches the contract. For example, by failing to deliver the promised accommodations or amenities. Certain conditions, however, can invalidate or complicate a rescission claim. If a purchaser fails to deliver written notice within the 10-day window, the contract becomes binding, and rescission rights expire. Additionally, if the purchaser knowingly waives the rescission right, though such waivers are generally unenforceable under Arizona law, the courts will examine whether the waiver was executed voluntarily and with full understanding. Miller v. Sedona Pines Resort, LLC is an Arizona Court of Appeals case that reinforces the strict consumer protections of the Arizona Timeshare Act by holding developers to mandatory rescission and refund requirements. In the case, the purchasers timely exercised their statutory right to cancel a timeshare purchase, but the developer failed to promptly refund all monies paid. The court ruled that once a purchaser properly cancels within the rescission period, the developer must refund all payments, including deposits and other consideration, within the statutory timeframe and may not delay, condition, or reduce the refund. The decision emphasizes that timeshare cancellation and refund provisions are consumer protection statutes that must be strictly construed in favor of purchasers, and a developer's failure to comply constitutes a violation of Arizona law. In addition to the 10-day statutory rescission period, other circumstances may render a timeshare transaction rescindable under Arizona law, including misrepresentation, fraud, or failure to provide the public report before the buyer signs the contract. According to ARS Section 32-2197.19, any sale made in violation of the Timeshare Act or through fraudulent means may be rescinded by the purchaser within 3 years of the violation being discovered. This provision extends consumer protection beyond the initial cooling-off period when the developer has acted in bad faith or failed to comply with statutory obligations. For instance, if a developer fails to disclose a lien or encumbrance on the property or advertises access to amenities that do not exist, the purchaser may seek rescission even after the 7-day period has expired. Similarly, if a salesperson knowingly provides false information about the resale value or future appreciation of the timeshare, the transaction could be rescinded on the grounds of fraudulent inducement. The Arizona Department of Real Estate, ADRE, plays a vital role in enforcing these protections. When purchasers file complaints alleging violations, the ADRE may investigate and, if warranted, impose administrative penalties or refer cases to the Arizona Attorney General's office for prosecution under the Consumer Fraud Act. Arizona Revised Statutes, Section 4452. Review Summary. A timeshare transaction may be rescinded under ARS Section 322197.03 within 10 calendar days of signing the contract or receiving required disclosures. This unconditional right of rescission allows buyers to cancel without penalty, ensuring fairness and protection from high-pressure sales tactics. Developers must honor all valid rescission notices and refund payments within 15 business days. Beyond the 10-day window, transactions may also be rescinded for misrepresentation, fraud, or statutory violations. Discussion prompts. Why does Arizona provide an unconditional 10-day rescission right to timeshare purchasers? Answer. To protect consumers from impulsive or pressured decisions made during sales presentations, and to ensure they have time to review the agreement and disclosures. What must a developer do after receiving a valid rescission notice from a purchaser? Answer. Refund all payments within 15 business days of receiving the notice. Under what circumstances may a purchaser rescind a timeshare transaction after the 7-day period has expired? Answer. When the sale involved fraud, misrepresentation, or failure to comply with statutory requirements, such as providing a public report. Closing remarks. Arizona's rescission laws reflect a philosophy of fairness and consumer empowerment in real estate transactions. The right to rescind gives purchasers a crucial pause between emotional decision-making and contractual obligation, ensuring that commitment to ownership is both voluntary and informed. For real estate licensees and developers, honoring this statutory right is more than compliance. It is a reflection of ethical business practice and public trust. Understanding when and how rescission applies not only prevents disputes, but also upholds the integrity of Arizona's real estate system.